In the latest legal battle, WP Engine wiped the floor with WordPress, Automatic, and Matt Mullenweg. Let's go over what happened and how it'll affect both the companies and the users. My name is Dennis Walsh. I'm an intellectual property attorney and software developer discussing legal issues in software. In this video, I'll go over what happened in court and what it means for the users of WP Engine. So backing up for a second, if you're unfamiliar with the legal battle between WP Engine and Automatic, I made a video explaining it here. In that video, I first go over the dispute and the drama, and then I cover the motion for preliminary injunction against Automatic. Essentially, WP Engine wants the clock turned back to September. Then also in that video, I went over the merits of WP Engine's motion, and I said there was no question that WP Engine would prevail, and I was proven right. Here's what happened in court. On September 26th, there was an hour-long hearing between WP Engine and Automatic in San Francisco. I don't have the transcript yet, but the outcome was the judge ordered both sides to craft a proposed order to grant the preliminary injunction. So let's go over what I said in the original video, and we'll contrast that with how the court ruled. Remember, to grant a preliminary injunction, the court must first find that the moving party is likely to succeed on the merits. My original video covers 5 of the causes of action and the likelihood of that success. Here's what I said about WP Engine's claim on the tortious interference with contracts claim. I think the next cause of action is a slam dunk, intentional interference with contract. WP Engine claims that Automatic tried to damage its relationships with customers and partners by undermining its ability to provide reliable services, specifically MAT statements and the WordPress loyalty pledge. To show intentional interference, WP Engine needs to prove that Automatic intentionally acted to disrupt WP Engine's relationships with third parties. All of Matt's statements, plus the crazy login loyalty pledge, makes this one, frankly, a slam dunk. Automatic and Matt tried to interfere with WP Engine's third-party contracts. There's really no question about it. And the court found the same by, unsurprisingly, using Matt's own words against him. Specifically, quote, "I know that this is the nuclear option. It sets us down a specific path." Quote, "If you're saying next week, that's saying no, so I will proceed with the scorched earth nuclear approach." Also, quote, "I don't think they're worth a fraction of that now. Customers are leaving in droves. It's a distressed asset." And finally, I suspect that there are going to be millions of sites moving away from the ACF plugin in the coming weeks. I guess you'll have to wait and see. Maybe people do not trust ACF as much going forward. So I'm going to have to take a victory lap on that one. The court only addresses the likelihood of the merits of the slam dunk tortious interference claim because it only needs to show the likelihood of success on one claim. We both agree that that one was easy. They dispensed of it quickly. There is an interesting footnote that at the hearing, WP Engine thought their extortion claim was their strongest. Given the ambiguity in the law for the attempted extortion, I'm not sure why they think that, but obviously I and the court both agree that the intentional interference with contracts is their best. The next factor to decide is irreparable harm. For this one, I thought, now turning to the second factor of the preliminary injunction, will WP Engine suffer irreparable harm? Given Automatic and Matt's role as the WordPress gatekeepers coupled with Matt's rhetoric, it's hard to imagine that a simple check will adequately mitigate WP Engine's harm. If doubt is created in their customers' minds as to their ability to service their websites now and into the future, a check from Automatic probably will not fix that damage. I think this factor tips in favor of WP Engine. And the court agreed. Specifically, she sided with WP Engine's argument that, quote, "The requisite irreparable harm is present here because it has suffered loss of existing and potential customers and damage to those customer relationships, loss of market share, and loss of goodwill and reputational harm, in addition to the harm suffered by the customers and the larger WordPress community." And, predictably, the court dismisses Matt's arguments as not persuasive. Yikes. The third factor is the balance of equities. I thought, will the equities tip in favor of one party? Matt helpfully shot his mouth off and admitted that, quote, "If we lose the injunction, what happens? Well, we'll have to go back to the state of what they were beforehand when they had access to WordPress.org. So that's fine." Clients like these are the worst. So by Matt's own admission, the equities are in favor of WP Engine. And here's how the court ruled. Quote, "The conduct described at length above, including the termination of WP Engine's access to WordPress, the interference with ACF plugin, and the additional burdens imposed on WP Engine's customers, such as the sign-in pledge, demonstrates that WP Engine has a significant interest in obtaining a preliminary injunction relief." And here, however, WordPress has been, until recently, available to WP Engine on the same terms as other users, or at least on the same terms that were in place up until September 25th, 2024. Regarding defendants to restore access to those items while this action proceeds imposes a minimal burden. Therefore, the balance of hardship tips in favor of WP Engine. And the final factor. Finally, the last factor is public interest. This is where I think the granting of a preliminary injunction is frankly a given. For this suit, churches, restaurants, and other customers of WP Engine are part of the public, and they are collateral damage in this heavyweight spat. There is a huge incentive for the court to return the status quo pending litigation on their behalf. The court here rules that, quote, the public consequences of withholding injunctive relief are significant. Mullenweg himself acknowledges that, quote, today more than 40% of all websites run on WordPress. Over 2 million websites run on ACF plugin Mullenweg allegedly tampered with, and those users rely on the stability of the plugin and WordPress more broadly to operate their websites, run their businesses, and go about their day online. Maintaining that continuity and preventing arbitrary disruption stemming from a corporate dispute is in the public interest. So now that the court found that all 4 factors were satisfied, what happens in the order? What are they enjoined from doing? The order undoes all of Automatic's and Matt's actions. Specifically, Matt and Automatic are enjoined from blocking WP Engine's access to WordPress.org. They must restore all WP Engine employee access to WordPress, disable any blocking, restore all API access, data resources like WordPress themes, secured resources, and support resources. And not surprisingly, they must remove the loyalty pledge checkbox and restore complete access and control over WP Engine's advanced custom fields plugin. What happens now? The status quo is returned for WP Engine and its users pending the outcome of the case. Automatic will file a motion to dismiss on December 19th. WP Engine will respond January 22nd, and Automatic will finally reply on February 5th. There will likely be a hearing and a ruling shortly thereafter on Matt's motion to dismiss. I've read WP Engine's amended complaint and Automatic's original motion to dismiss. A motion to dismiss requested the court dismiss the action because, despite taking everything the other side says is true, the non-movement failed to present a viable case as a matter of law. That's a high bar, and most motions will fail. That said, in cases this big with this many allegations, normally the motions to dismiss will pick off a few claims. In this case, though, WP Engine's claims are so strong, and given the court is clearly on WP Engine's side, Automatic will lose most, if not every point in their motion. The bottom line is the substantive parts of this case will absolutely continue. So what happens after Automatic loses their motion to dismiss? It's going to depend on how far WP Engine wants to go and what Automatic will offer in settlement. If I were defending Automatic and Matt, I'd be looking to settle now. It's both a good legal and a good business decision, and it's clear the court is not on your side. But Matt looks to be fully entrenched in what I see as little man syndrome and may continue this pissing contest unabated. And if he does, I'll keep covering it and other software legal issues. So what do you think? Is it a fair ruling? Bad ruling? Am I giving short shrift to WordPress? Let me know your opinions and questions in the comment. And if you found this video helpful, please like the video so I know to keep doing this. And then subscribe for the next video where I'm going to go over the law behind website accessibility and what's actually required to keep you and your websites on the right side of the accessibility law.